Here's an update on Robert Morris. According to articles, he was arraigned this morning in Oklahoma. And yesterday, at the end of a video I did, a quick update in regard to, well, I was addressing Paula White, but I did a quick update at the end in regard to Robert Morris. I said I was going to do some research. I've done some research into what I was looking for is what his sentence could possibly look like. Remember, I mentioned that people are saying that he's looking up to 100 years? Well, that might be accurate. In my experience, I typically would not see the stacking like that, the consecutive nature of potential charges where it's, in this case, he's looking at 3 to 5 years for each count. It's 5 counts that he has been charged with. And that's the range of the sentence. And in some states, they have what is referred to as indeterminate or determinate sentencing, meaning they could get like a range of years. I'm not sure yet. I'm still researching what that looks like for Oklahoma, whether he could get, like, say, 5 to 15, something like, well, 5 to 20, if that would be, that's the maximum. For instance, in Michigan, the type of crime that he's similarly indicted for, if it's on the touching only, that would be up to 15 years. If there's penetration, then it could be up to life. It just depends. So that's for Michigan. Now, again, going back to Oklahoma, what he has been charged with, it is a maximum of up to 20. And I did read an article over the weekend where a defense attorney in Oklahoma was interviewed by a reporter, and that defense attorney said that in Oklahoma, there is an incentive to plea, meaning to take a plea deal. And they're incentivized to do this because if they go to trial, then they could get a consecutive sentence. Now, when I did my research on just that statute, the ones that he was indicted on, it looks like, from what I could see, I have to go back and look further, but it looked like the jury might have a say on what the sentence is. And so I'm not sure what that looks like, but from here, he's been arraigned. He does have a $50,000 bond. Not sure of the percentage that he has to pay, whether that's a cash, that he has to fully come up with it. The articles that I read, it just said he paid his bond, so maybe he paid the whole $50,000, not sure. He is required to surrender his passport, and then his date that he goes back to court is not until May 9th is what I read. So that's about 6-7 weeks away. What happens there? Well, it could be called a calendar conference. Sometimes it's just called pre-trial. It could just be a conference, and then they kind of set the dates of discovery, any motions, and we all are going, well, at least I, and I know other people that have been talking about it online, will anticipate that there is going to be a challenge to the charges, because he is going to argue, perhaps through his attorney, that he should not be charged because the statute ran. But as you may recall, the AG's office is using a statute that has been on the books for a long period of time. And if you're interested, it's 2024 Oklahoma Statutes Title 22, Criminal Procedure, Section 22-153. And it states, quote, if when the offense is committed, the defendant be out of the state, the prosecution may be commenced within the term herein limited after his coming within the state, and no time during which the defendant is not an inhabitant of or usually reside within the state is part of the limitation. Oh, it's legalese at its finest. So the heading of this statute is absence from state, limitations doesn't run. That's really what it means. So because he wasn't in the state, they did not have the statute of limitations that applied to this crime. There was a term that the Attorney General used that I was concerned with. He said flee. That's the word I saw that was utilized in an article. It could have been that he was just referring to the rationale back when they instituted this statute, that marauders, people that were committing crimes, they didn't live there, they were going state to state in the frontier states, and it was, this law was for that, to bring people to justice and the statute would not run so that they could hold them accountable when they did catch them. And he used the word flee, and so I thought that that word might be in the statute. It is not. So the reason that I was concerned was if an argument could have been made that he fled the state, and in one of my videos I said that that's not factually correct, because everybody knew where he was. He didn't flee, he was coming back and forth because he was visiting friends. And so in any event, that's a red herring. It's neither here nor there, but that just to go back and track what I was saying if you have any questions on that. So what we're looking for going forward, well, probably nothing until May. So, he's been arraigned, and of course he was going to plead not guilty. I do anticipate that he is going to fight that statute. Another thing that I'm seeing people is, oh, he's going to plead. I don't know. I mean, I would suspect, based upon his age, I think he's 63, that he has enjoyed the good life for so long, and there is at least one motion that he might be able to, his attorney will be able to entertain before the judge, which is the challenge of that statute, which it serves to just kind of extend things. And he's been living his life. And so my impression, and this is just my impression, is that he's probably going to try to kick that can down the road. I think that, whatever motions that his attorneys can bring, they'll bring it, because it would extend the time of a potential trial and keep him out of jail and prison. So the sentence that he's looking at is not prison. I'm sorry, it's not jail time, it's prison in the Department of Corrections. And I guess we just have to see. Another thing to keep an eye on is whether or not there's going to be a plea that's offered to him. The state might offer him a plea. I don't know. I mean, we just don't know at this point in time. He could potentially just plead straight up to the judge without any plea agreement, and then it would be up to the judge to decide the sentence. If the state offers something, then it would be, I would expect a period of years and probably conditions to that, and maybe to get some restitution, because I don't know if Cindy Clemenshire is going to have a civil case. If she is, if there's any money, and I'm sure she's not after any money. She was initially just after trying to get reimbursement for what she paid out for her counseling. If there is that aspect of it where she would be awarded restitution, it would have to come with either a plea deal or he's found guilty, and that's part of sentencing. So that is where I'm at right now, and I will continue to keep you informed if there's something else that comes out in regard to his arraignment and moving forward with the charges, getting a court date set, trial date, and hopefully they'll have a trial date set when he goes in front of the judge in May. That's possible, but again, what might happen is they might hold off on that unless he asserts his right to speedy trial, of course, and because I do believe that there's going to be some motions that we see. So I hope that this is helpful, and I will see you in the next video.